Welcome to the Bar Mock Trial Competition. This is one of the enrichment options that's available to you, and I think it's an amazing opportunity. It's not great just for those people who are considering a possible career in law and are thinking about that sort of future, but actually it's great for anybody who wants to develop a skill set that's so easily transferable to a number of other careers and career opportunities. So within this opportunity, you will be looking at developing your teamwork, your critical analysis skills, the ability to collate information, pull it all together, as well as being able to present a case, public speaking, and generally the range of soft skills that are looked for in not only degrees but school leaver programs and higher level apprenticeships as well. So why do this particular opportunity, this particular competition? Well, I think, as it says on the screen there are three things that it really does do for you. Number one, it just gives you a wider education of the legal system. That ability to understand different types of or different areas of the law. Cases that you will look at might go from anything from theft to fraud to GBH. So there's a number of things that the cases involve that open your eyes to the actual law around those areas. The second thing is the introduction to the legal profession in itself. Many of you might be thinking about the law or have considered going into law as a future career, but might not know a great deal about it, or might not have anything tangible that you can sort of portray at an interview or through your personal statement when you're applying to university. So this gives you something tangible that you can say, look, I did this competition, and within this competition it allowed me to do this, this and this. And so you've got something tangible that you can take with you. Beyond that, actually what this does is it gives you the chance to look at real life, look at cases, be able to take those cases apart, and ultimately the combination of the competition is to either prosecute or defend two cases in a court of law. And that's an amazing opportunity. And the last thing I've already touched on already is that sense of the range of skills that you will develop by going through this process. And those skills, as I say, are transferable in so many different areas of life. So three really, really key sort of outcomes that you'll get by doing this competition. And I think they're a great opportunity for anybody to take advantage of and to really flourish and develop as individuals. So what does the competition actually involve? Well, firstly, we take a team of 15. So although there might be more people involved in doing this enrichment option, and it's great to have more people involved, on the day 15 people will go to a court of law to actually compete. But more people can be involved in terms of the background work. The legal system and the legal profession as a whole isn't just those people that stand up in court and either defend or prosecute. There are so many other people involved in the preparation of a case, and this is the reality of this competition too. But on the day, 15, and you can see the roles that are there. I'm going to go drop straight down to the bottom to the jurors. So there are 5 jurors. Now, as a juror, you will be part of the jury, but you will be the jury for another 2 schools in their courtroom, prosecuting and defending a particular case. So you won't be the jury for Herts and Essex, you'll be the jury for another courtroom. But the jury is a great role. You are involved at every stage, all the way through this process. But if you didn't quite fancy a public speaking role, one that put you in the spotlight, but you still wanted to get a real clear idea of how this works, a juror role is great for you. Going straight up to the top, 2 prosecution barristers, 2 defence barristers, 2 prosecution witnesses, and 2 defence witnesses. The reason for that is that there are 2 cases, and for each case we have to prepare a prosecution and a defence of that case. We don't know until the day itself whether you are prosecuting or defending. So we find out on the day, so we will have prepared both sides and we'll have those teams ready to go. Your prosecution and defence barristers, they are the ones that are going to do the bulk of that public speaking. So being able to think on your feet is another skill set that's developed from this, as well as public speaking, as well as the ability to cross-examine a witness. The witnesses, well, that's a great role. We sometimes have drama students who are also interested in law, who take on the role of a witness, and that's a brilliant opportunity for someone to really get into character. And the more you get into character, the more you create that real life courtroom environment, the better the team score overall is. But you've got to learn your particular witness statement. You've got to know the ins and outs of it. You too have to be able to think on your feet. You're going to have another school cross-examining you, and you are going to have to be able to respond to those questions based on your witness statement, but also perhaps have that ability to play the part within the courtroom. You've got the court clerk and the usher. Both of those are very much about making sure the courtroom environment works smoothly, the case runs smoothly. The clerk has a bit more of a speaking role in terms of the fact that they will read the indictment in itself. They'll read the Section 9 statements. So these are statements that are brought to the courtroom but are not involved in terms of the witnesses. And they'll swear in the jury, and there are certain administrative tasks that go with that. The usher, again, goes through the process of, in this case, they're swearing in the witness, but they make sure that the timing of the case runs smoothly. So a range of potential roles which plays to the strengths of a range of individuals. And if there's areas that you as a person want to develop, then you can take on a role that develops that skill set. If there's other areas where you think, actually, my skill set's better suited here, and I really want to develop that, then you can go with that role as well. Not only that, but we've also got a number of students within these photos who have gone on to study law at university. Martha Obolo in the top picture went on to study law at university. Within her first year at university, won the law prize, and has said that her experience through the bar mock trial was certainly integral in terms of her understanding of law and her passion for law. Elsewhere, we've got students who've gone on to do things like history degrees, politics degrees, economics degrees, and then have done a law conversion course at the end of it. So not everybody goes into the law having done this competition, but everybody develops a range of skills that certainly helps for their futures. So this is a little bit more of a view of Snaresbrook. Obviously on the left hand side you've got the major external building of Snaresbrook. It's a lovely building. On the right hand side you have got a courtroom that you will present in. So this is one of the Crown Courts, and you've got the area of the jury across on the far side, the judge at the top, the court clerk sits in front of the judge. You've got the witness box, and if you're a witness you will stand in that box and you'll be sworn into that box. And then you've got the areas where the prosecution and the defence will present from. The bit that you can't see is where the witness sits, but you will be in that environment. And whilst daunting at first, it's a great opportunity to really flourish and take advantage of. So an exciting opportunity for you. And the reason why it's important to have a look inside a courtroom is because not only are you going to work on the case itself and you're going to work on the aspects of the case, but you're also going to learn court etiquette too. So what you can see here is exactly where everybody is placed within that courtroom environment, and you will take those places. What's also interesting is that the defence sits the closest to the jury. In whatever courtroom, the defence sits the closest to the jury, and the prosecution the furthest away from the jury. So little bits of court etiquette, really important. And again, it's all part of the peripheral areas of the competition, but they're all judged, they're all marked. The judge sits at the top. These are all practicing judges. They give up their time for free on a Saturday to judge your cases. So they are all practicing. They're all in their robes, they're in their wigs. They judge your case. They'll give immediate feedback at the end of that particular case in that particular round of competition, but they'll also give written feedback to the school at a later date. So you are going to have a practicing barrister support you. You are going to go to a Crown Court to present your cases, and you're going to have a practicing judge judge you. If you want an insight and a real tangible outcome from the legal profession and a way to support your future aspirations, what better way than to take part in this competition? And here we are. So this is one particular case. So what I suggest you do here is you take a couple of minutes, stop the video, have a read through, and just get a bit of a sense as to the case itself. And what I'm going to show you in the next part of the video is what the actual indictment is, and what our team had to prepare in terms of a prosecution and a defence, because you could be asked to do either. And just to get you to start thinking a little bit about the actual scenario, the bit of critical thinking, some analysis here, but also to get a sense of the case itself. So pause the video, have a read through, and then we'll move it on in terms of looking at the indictment. And here is the indictment. So it's the Queen versus Blair Forrester. So Blair Forrester is charged as follows. Count 1. The statement of offence is of throwing corrosive fluid with intent to do grievous bodily harm under Section 29 of the Offences Against the Person Act 1861. The actual particulars is that Blair Forrester at around 12:40 a.m. on the 19th of May 2018 purposefully and maliciously threw a corrosive substance which caused extensive injury to Max Addo. So that's your case. Prosecute Blair Forrester or defend Blair Forrester. You have some information which we've already had a look at, and we're going to have another look at it. There would also be a number of witness statements, and those would be the roles that our witnesses would take on. And all of this information would be what you as a team would sit down, work your way through, take apart, and then build your case, either as a prosecution or as a defence. An important point of law here, which is about burden of proof. So given this situation, and in all cases of law, the burden of proof lies with the prosecution. It is the job of the prosecution to prove beyond reasonable doubt that this event took place and that the person indicted is guilty. The burden of proof sits with the prosecution. As a defence, you don't have to prove anything. You do not have to prove that your client is innocent. Your job is fundamentally to create enough doubt so that it is not beyond reasonable doubt. And therefore, by creating that doubt, by creating that sense of, oh, I really don't know, then you are in a position where your client can be deemed innocent. So you don't have to prove innocence. Remember, the burden of proof sits with the prosecution. You just create doubt. The burden of proof sits with the prosecution. They have to prove, in this case, that Blair Forrester purposefully and maliciously threw a corrosive substance which ultimately created and caused grievous bodily harm. So that was this particular case. Now remember, in the actual competition, you'll get 2 cases. There have been ones of fraud and theft, various different scenarios that give you an insight into different areas of the law. So here's where we're going to go next. I'm going to bring up the case again, and we'll have a chat through the sorts of things that you might have picked up on. So again, what I would suggest here is when the case comes up, pause it, have another read, and start pulling out those things that you could probably question. Are there some inconsistencies? Are there some coincidences? What are the things that you're looking for to start to pull this apart? Whether that be from a defense point of view, a prosecution point of view, you're going to be looking at the same bits of evidence, but from a slightly different perspective. So here's the case again. As I said, pause it, start working your way through it. Alright, so hopefully you've had a bit of a pause and you've been able to pull out a few things. So just a few things that you possibly, hopefully, you have picked up on. So I'm just going to highlight a couple of things that perhaps are quite key here, that perhaps you could look at in terms of either prosecution or defense. Alright, so what we have here is we have Blair Forrester turning up to a party uninvited. And that party, that uninvited attendance at a party occurred at 10:20 p.m. Okay. At this point, Max Addo and the friend Tommy Moore refused Blair entry and pushed Blair onto the pavement. Alright, so we know that this is what happened at roughly 10:20 p.m. Now, what we also know is that the attack happened at approximately 12:40 a.m. That's another 2 hours and 20 minutes. So you could argue that Blair is angry, is irate, has been ridiculed for turning up to a party uninvited, been pushed onto the pavement, and therefore has sought retribution. But you could also counter that and say, well, has it really taken that individual 2 hours and 20 minutes to then respond to that rage and that sense of injustice? It's taken 2 hours and 20 minutes before that's happened. Okay, so that's one potential argument here. All right, let's have a look at this 12:40 a.m. So at 12:40 a.m., we've got this. Max was crossing the front garden to enter the house. At 12:40 a.m., middle of the night, you would argue it's probably dark by that point of view. But they became aware of something striking. Okay, so this was the acid attack. Now, Tommy, who was with Max at the time, claims they ran out and saw a person fleeing the scene. Now, a couple of things here again that hopefully you picked up on. Number one, the person fleeing the scene. So the person is going to be running away from them. So can they identify them? Is there clear identification of them? The second thing that I think is slightly interesting is that Max is saying that at 12:40, Max was crossing the front garden to enter the house. And yet, Tommy claims they ran out. Now, who's they? Because Tommy's saying that they were with Max, but Max was crossing the front garden. So there's a concern here about consistency of story. There's then the description of wearing light blue jeans and a brown jacket, broadly matching the clothing worn by Blair at the time of the arrest. So the person's running away. It's dark. We're not sure whether Tommy and Max ran out of the house, whether Max was already outside and Tommy was inside. And they're wearing light blue jeans and a brown jacket. And the person's running away from them. So possibly we can't even see their face. Blair denies going near Mance Road at any point after 10:30. It's Blair's case that when arrested, she was just going to the late night petrol station to pick up snacks. Okay, so the police have examined the phone. Now, what's slightly interesting here is that there was a phone call at 12:47 a.m. to the cousin. Okay, so you've got this taking place with the cousin. It's a 16-minute phone call, coincidentally 7 minutes after the attack, but a 16-minute phone call in which they discussed which snacks to purchase and their favourite Netflix series. 16-minute phone call at 12:47 a.m. about snacks and a Netflix series. The police also found a Google search for acid attacks made on the 15th of May. Now, is that coincidence or is that related? An acid attack made on 15th of May, 3 days earlier than the attack took place. And then Blair carries out an acid attack. Element of premeditation, possibly, or coincidence. Okay, so those are the things that hopefully you've picked up on. Hopefully these are the things that you would start to think about. Remember, burden of proof lies with the prosecution. As prosecution, you have got to prove beyond reasonable doubt that Blair actually did this. As the defence, you're creating doubt. Lots of information just in this summary of events, let alone then you going on and looking at your witness statements and taking those apart. All right, well, hopefully this has given you an insight into the bar mock trial competition. As I've said earlier, an amazing opportunity in terms of enrichment to develop not only a set of skills, but also to give you that background into the legal profession and the legal system. And for anybody that's looking at going on to do law afterwards, this is the best possible way to offer something tangible to anybody interviewing you or pre-university study. So there we have it. There's your insight. Hopefully that's been a useful video for you, that you've been able to get a real sense of what this is all about. And we are really looking forward to welcoming you to Hearts in Essex in September to join our sixth form and hopefully to undertake the bar mock trial as your enrichment. Many thanks. I hope you enjoy your induction and we look forward to seeing you in September.